the Zoom waiting room. We'll get to you. Chair calls Nina Perales. Did I say that right? Okay. I show you registered to testify as Nina Perales on behalf of the Mexican American Legal Defense and Educational Fund on revised congressional redistricting plan. Is that correct?
Yes, that's correct.
Thank you. Please give us your testimony.
Thank you. Mr. Chairman, Mr. Vice Chair, and members of the committee, my name is Nina Perales. I'm the Vice President of Litigation for MALDEF, the Mexican American Legal Defense and Educational Fund. We are the law firm that represents Latino individual voters and organizations in the current Texas redistricting litigation. And I'm here to answer any questions that the committee might have regarding that case. Among the coalition of Latino organizations that we represent from around the state is LULAC, and it's our great honor and privilege to represent LULAC as well as the other plaintiff organizations. We just finished a 3 to 4 week trial in El Paso, which dealt in part with the congressional redistricting. In that case, our claims include that the Texas legislature in 2021 did not draw a sufficient number of Latino majority congressional districts, and that in fact the growth of the Latino community since 2010, but certainly since before that as well, can support the creation of an additional Latino majority district in Harris County, in addition to 29 represented by Congresswoman Garcia, from whom you heard earlier today, as well as enough Latino population to support an additional congressional district in the Dallas-Fort Worth Metroplex. That would be in addition to Congressional 33, represented by Mark Vesey. In light of the growth of the population over the past 2 decades, Section 2 of the Voting Rights Act does require the creation of additional districts. If the committee and the legislature decides to take up redistricting, it is certainly true that you cannot subtract from the current level of representation that we have. That would violate the Voting Rights Act. And our final request would be to please allow public review and comment of any plans under consideration, because currently we're unable to comment on any proposed plans. Thank you.
Thank you for your testimony. Members, any questions for this panel? Chair recognizes Speaker Moody to question the panel.
Thank you, Mr. Chairman. Ms. Perales, I want to kind of highlight the last bit of your testimony. You talked about the ability for people to comment on any proposed changes. And well, let me start with this instead. And we've talked about it throughout the hearing, this letter from the Department of Justice to the Governor and the Attorney General. You've seen that letter?
I have, as well as General Paxton's response.
Okay, so let me ask you this, because we've heard from some other folks, and obviously I've known you for some time, and you have quite a bit of extensive history in litigating these types of issues. And so I'd just like to get your opinion on the letter that the DOJ sent to the state of Texas about these, about the need or constitutional concerns that they have.
We agree with the concerns raised by the first witness in this hearing, Professor Katz. With the letter, there's a number of things that are very odd or unusual about the letter. Perhaps it was hastily prepared, but it's factually incorrect when it refers to Congressional District 29 as a coalition district. As the law understands it, because Congressional 29 is over 50% Hispanic citizen voting age population, it is not a coalition district. It is a single minority Hispanic opportunity district. Another example would be the strange characterization of CD33, which is represented by Mark Vesey in Dallas-Fort Worth. That district was not created as a Voting Rights Act district, but rather a remedy for racial gerrymandering by a past legislature. And so the way that the letter was approaching these issues was just very odd and not consistent with reality.
So let me drill down onto the District 29 issue that you raised. Hispanic citizen voting age population, HCVAP. Anybody who's been in this process, they've heard that terminology. If you haven't, that's what it means. Why does that matter? Why does that threshold matter? Like, why do we look at that number? Is there a reason why we look at it?
There is a reason, and it's very important, because the Supreme Court has told us that if we're asking the question whether there needs to be, for example, in this case, a Hispanic majority district in a particular location, the very first question that the court will ask is, are there enough people there to constitute a majority, for example, of the Latino population? That is the very first question, and if you answer that question in the affirmative, as we have with 29 for several decades, then you move on to additional questions, resulting in the conclusion that the district is required by the Voting Rights Act.
And I think it's important to draw the distinction because HCVAP, different from HVAP, different from Hispanic population, right? So Hispanic population would be everyone Hispanic in a particular area, correct?
That's right. Hispanic citizen voting age population takes into account not just total population, but those over age 18, those who are U.S. citizens. So what you're really referring to there is the voter eligible population.
So if you've got, and in District 29 you said the HCVAP is what?
Comfortably over 50%.
Okay, so that's the status of it today. And so I just want the committee members to understand the Hispanic population in that district is far more than that, because we're actually winnowing down. The HCVAP is the lowest threshold because the court has told us we're going to gear off of that number. If we're going to afford protections, we're going to gear off of that number because those are the folks that can actually vote in that election, right?
Yes.
Okay, and so this letter identifies a district as a coalition district that is actually a majority Hispanic district. Tell me the difference and tell the committee the difference.
Well, as the law, as cases discuss it, a coalition district is where you combine more than one minority group to exceed 50%. And that may be the case in other districts. That doesn't tell us anything about its constitutionality or legality, but simply a coalition district is a coalition of minority groups. That is a different type of district than the district that is what we would say majority Hispanic, in this case of 29. The letter is factually incorrect when it refers to 29 as a coalition district.
So as a fundamental part of this letter, the Department of Justice has misidentified a congressional district as and look, I believe that there's a whole other conversation about protections for coalition districts. But this goes to the point of the reason why we are here is because a letter was written by the DOJ to the state of Texas. And in that letter, one of the 4 districts that were identified doesn't even qualify under what they say it qualifies as. And that's under Supreme Court case law.
Yes.
What is that? What do you take from that?
I take from that the letter perhaps was hastily prepared. It's carelessly written. It doesn't follow the standards that are used by the U.S. Supreme Court when it discusses these types of districts.
You know, I share your concern and the fact that we are here talking about this, and a letter coming from letters come from the DOJ. Probably, that's something you would take seriously. You're pointing out something that is factually wrong and has now become a premise for why we're here. I mean, it doesn't shock me. This is the same administration that levied tariffs on an island of penguins. But look, and I say that for a little bit of levity, but this is serious in that this is talking about people's representation and what matters to them. I want to go to the last point of what you raised in your testimony, and then that'll be the end of my questions. You talked about participation, the ability to participate. And we are grateful. I see here still 158 witnesses that have registered, either in person or virtually, that want to weigh in. And we have multiple hearings. There are a couple more hearings that are coming. But we have no maps in front of us. We have no bill in front of us. Do you think that this participation is meaningful for you when you don't have a map to look at?
I want to express gratitude for the opportunity to testify today. but the opportunity is a limited one if we are not able to comment on a proposed map.
Because you wouldn't know unless you saw something what communities are in a district or are being moved from a district, which institutions are here, there, wherever. I mean, you have none of that data in front of you.
It's impossible to know. And honestly, with the naming of 4 districts in the Department of Justice letter and what we read in the newspapers, which is all we know about certain goals that have been announced for the redistricting, if it's 4 districts, if it's 5 districts, the ripple effect from redrawing even one district can be substantial. And so we are potentially looking at a significant redraw of the congressional map, and it would be critically important to see maps under consideration and be able to comment on them so that the committee and the body understand what are the risks, what are the rewards, what are the potential legal liabilities.
Well, and I want to talk about, so you talked about the ripple effect. I think the members of Congress maybe mentioned that a little bit too in their testimony. Mm-hmm. Because when you're drawing these, and for those of you who haven't participated in this process at that level, when we draw our House and Senate districts, there's deviations, right? You can 5,000 down, or this, you can. There's a little bit of variance within the districts. When we're looking at congressional districts, that's different, isn't it?
That's correct. The U.S. Constitution requires that every congressional district contain the exact same number of people. So in the Texas Congressional Redistricting Plan, all of the districts have the same number, except for one district that gets have one more person.
So that's it. The deviation there is one person. So the ripple effect, when you move 5,000, 10,000, 15,000, I mean, because everything has to be identical, you will necessarily see a ripple effect across.
The ripple effect is greater in congressional redistricting because of the need to equalize population across
when we
the
have the ability to have a little bit bigger variance like we do in the House and the Senate, you could maybe massage that around the edges a little bit. But in congressional maps, as you point out, that is a 1-for-1. So yes. It is going to be exacerbated when you change one. The ripple effect is greater, is it not?
Yes, that's right. There's not the same kind of flex that you would have in Senate redistricting or House redistricting. And
I know in our when we do our redistricting in the House side, we talk about breaking county lines, and that has a lot of legal significance. Not that we don't do it, but it has legal significance. Any rule like that exists in congressional redrawing?
Not in Texas, no. So congressional districts can insert appendages into as many districts as they want to, and often they do for various reasons. Okay. And thus the sort of wider ability to draw and the tighter requirements on population mean that the ripple effect can be very strong.
Ms. Perales, thank you so much for your testimony. I appreciate your time.
Ms. Wu, for what purpose? Okay. Mr. Turner, for what purpose? Recognized for question witness.
Thank you, Mr. Chairman. Thank you both for being here. Ms. Perales, I have a few questions just to follow up on your testimony and your dialogue with Speaker Moody. First, I think you were being very humble as you introduced yourself, but I want the committee to understand the scope of your experience and expertise as a lawyer who has specialized in voting rights and redistricting litigation. Am I correct that you have argued numerous cases in federal court over the years, both on Texas redistricting and voting rights? Is that correct?
Yes, I have.
Okay. Is that including the United States Supreme Court?
Including successfully in the United States Supreme Court in the Texas redistricting case, Lulac versus Perry.
Very good. Thank you. So you have considerable expertise as to what the requirements of the Voting Rights Act of 1965 are, as well as the constitutional requirements with respect to redistricting. Is that fair to say?
I am familiar with the standards.
Very good. Humble, as I say. Well, I want to, while you're here, I want the committee to be able to take advantage continue to take advantage of your expertise and experience. You mentioned in your testimony that the legislature in 2021 had the opportunity to create two new Hispanic opportunity districts, one in Houston, one's anchored in Houston, Harris County, and the other anchored in the Dallas-Fort Worth Metroplex, where I'm from. And of course, the legislature, while there were proposals to do that, those proposals were rejected by the majority, and those did not become law. Is that right?
That's correct.
Okay. And that is one of the subjects of the recent trial in El Paso. Is that right? Of which the decision is still pending?
Yes.
Okay. In that trial, which you referenced, what was the state of Texas arguments as they defended those 2021 maps? Did they did the state contend that they drew those maps based upon race?
No, I would observe, and I don't think the team who tried the case for the Texas Attorney General's office would disagree. One of the critical points of the state's defense of its congressional redistricting plans is that they claim they were drawn blind to race.
Drawn blind to race. Okay. So that testimony would appear to be somewhat contradictory to this Department of Justice letter that the governor received in early July this year. Is that right?
Yes, the testimony is that the maps were drawn race blind. The DOJ letter asserts there's evidence showing that the maps weren't race blind. The Attorney General's response to the Department of Justice is that the maps were drawn race blind. Okay.
So we have a disagreement then between the Department of Justice and the official position of the state of Texas from our Attorney General's office.
Yes, there is a disagreement.
Okay. You mentioned that the Voting Rights Act does in fact require the creation of opportunity districts or majority minority districts in certain circumstances. Does the Voting Rights Act require identifying majority minority districts, be they coalition districts or otherwise, identifying them and then dismantling them? Have you ever seen such a directive from the Department of Justice?
I've never seen such a directive from the Department of Justice. I've been doing this since the mid-1990s. There is nothing in the Voting Rights Act that requires a district to be identified as majority minority and then dismantled because it's majority minority. There's also nothing in the Constitution that requires that.
Okay. And then finally, the four districts that were identified in that DOJ letter, were those districts redrawn substantially in 2021?
They are all different from the versions that existed in the preceding decades redistricting plans. Yes.
Okay. All right. Thank you very much.
Dean Thompson, for what purpose?
Follow-up question, please.
You may.
How were those districts drawn? They said they were drawn. You said it was all differently. How?
Well, from decade to decade, because population tends to shift and move around, and because there is the requirement that every congressional district have the exact same number of people in it, after the census data is released, there's always going to be some changing in the lines. So there is no district that remains exactly the same because it would have the wrong number of people in it. But the extent to which you change the district can be largely driven by whether its population is close to what we call the new ideal. And at least in Harris County, I believe, at least for congressional 18 and possibly also 9, those districts were very close to the ideal population. They only needed minor modifications to bring them into the population deviation rule. And Texas, in any event, changed their boundaries even more. So it cannot be said that these districts, if they were drawn in some way that a lawyer would say is not right, are still drawn that same way today.
And if I can add on District 29, when it was designed to be a Latino district, we end up having Gene Green, a white man, representing the district for 25 years.
I was here when that district was drawn.
Only recently we have Sylvia Garcia, who has
Yeah.
in office for 6 years.
Yeah. Ben Reyes ran for that district when it
That's
was
right.
first drawn.
Uncle Ben.
Thank you very much.
Thank you, Dean. Vice Chair Rosenthal, for what purpose?
Witnesses.
Chair recognizes Vice Chair Rosenthal, the question witness.
Thank you, Mr. Chairman. I actually don't have much of a question. I just want to thank you both for being here. Ms. Perales, I'm going to say there are very few humans on the face of this planet that can take such complex things and break them down into simple terms that help us understand. So my father was an advanced research scientist in mathematics, which is pretty complicated. And he used to say the most brilliant people he knew were the ones who could make something so complicated sound so simple. So thank you for bringing your expertise today.
Thank you.
If I can also add, if we notice these two districts, well, the 3 districts are being looked at in Houston and Dallas. Have y'all noticed the time frame? It's FIFA 2026. So we're disrupting dollars as well. So I hope that stays in the back of my mind. I'm an accountant, so I follow numbers. That's why I pointed out that it's cost us $1.2 million to call this special session, which should be the focus of the disaster that has happened in the Hill Country and Leander. Thank you.
Representative Spiller, for what purpose?
Question the witness.
Chair recognizes Representative Spiller, question witnesses.
Thank you, Mr. Chairman. Ms. Prowse, I'd like to follow up on some of the questions. I appreciate, first of all, let me say this, and I'm going to try not to completely demonstrate my ignorance to the world today in asking you some clarification questions, but you and I may not politically agree in some areas, but I do respect your testimony, and I appreciate your testimony, appreciate you being here today. I'm trying to better understand some of your testimony, in particular the questions that Speaker Moody asked relative to Congressional District 29, because as I understand, you said that it is not a coalition district. Is that correct?
Okay.
That's right.
Are the other 3 that are enumerated in the DOG letter, do you know and would you identify those as coalition districts?
I know that they're not Hispanic citizen voting age majority districts,
Okay.
but I could not tell you off the top of my head what the citizen voting age population is of the various racial groups in those districts.
And why can you not tell that?
Because I look at a lot of tables and maps every day, and I don't know those numbers off the top of my head.
Are there other coalition districts within the state that were not listed on the DOG letter?
I'm not aware.
So there may be?
I'm not aware.
You just don't know? Okay. And as I understand it, and you just finished your trial in El Paso, and there has not been a ruling in that case yet, correct?
There has not. We are preparing our post-trial findings of fact, proposed findings of fact, and conclusions of law.
All right. And you're familiar with the Petway case, Petway versus Galveston County?
Yes, I am.
And you would agree with me that it is currently the law of the land in Texas relative to coalition districts?
Yes, what the Fifth Circuit tells us is the law of the land.
Right. Well, and by that I mean that's not been considered or overturned or anything by the U.S. Supreme Court at this time.
That's right.
Okay. So, and is it fair to say that the Petway case that was ruled upon in 2024 was certainly after the maps that we're looking at today and the subject of which you litigated that were created in 2021?
Petaway came after the creation of the 2021 maps, yes.
But the subject of your trial was not really focused on coalition districts per se, was it?
No, that's not exactly true.
Okay.
If I could explain.
Sure.
There were various claims and remain various claims in this case. This case is 6 consolidated actions, so there's a lot of complexity and a lot of different claims. Some of them have to do with what are characterized as coalition districts. When the Petaway decision came down, it became the focus of the court and the parties to understand what Petaway means and what its impact would be on the Texas redistricting litigation. So there was extensive briefing, and the parties modified. Some of them modified their complaints as a result to conform. The U.S. Department of Justice was there. They had, meaning the U.S. Department of Justice, had about 7 months to absorb the Petaway decision and decide what it meant for them and for the law. And then the Department of Justice dismissed its claim on Petaway. One would expect that if the Department of Justice had changed its view on the Texas redistricting plans, that it would have simply articulated that within the litigation. But instead, at the conclusion of everything involving the Petaway briefing, the Department of Justice dismissed out and left the case.
Question: did the DOJ, when they dismissed or non-suited their claims in that case relative to coalition districts, was that before President Trump took office?
The DOJ never had coalition claims in the case. Their claims were more closely aligned with the Hispanic majority districts. But yes, actually, the Department of Justice did not dismiss out until March, so several months into the term of our new president.
Okay. And we've heard quite a bit of testimony here today and relative to the process. And you know, as you're sitting here today, do you know of anything that's illegal or unconstitutional about the Texas legislature or this committee considering, regardless of whether or not you like the way that the DOJ letter was drafted, but basically to consider what's on the governor's call to consider redistricting in light of Petaway?
There's sort of, the reason I hesitate is just because I feel like there's a couple of questions within that question. Is there a constitutional or a legal bar mechanically to mid-decade redistricting? Not as we understand it from the Lulac v. Perry decision. Is this letter a sufficient basis to call the legislature back in?
I'm not asking about the letter.
Yes,
I'm not asking about the letter. I'm just talking about the process that we're here today, because we've heard testimony from a number of people. But I'm assuming that your opinion is we have the right, as if the governor puts something on the call and we consider that, and we're sitting here considering that and considering testimony like yours today, that we have every right and maybe obligation to do so, and then make a determination whether it would be proper to amend those in light of the Petaway decision or not.
I would say that I am not an expert in state law or the obligation of the legislature to address items on the governor's proclamation for a special session. Okay. Do legislatures like Texas primarily carry the responsibility for redistricting? Yes. Should the legislature have a good reason to do so? I also believe yes, and that reason is not present here.
Right. I thought you might have that opinion. That's okay.
Apologies.
But let me ask you that. But on the let's go back to Petaway, because the way I understand it and read it, and again, I'm trying not to show my ignorance, but previously you had the Bartlett versus Strickland case, which basically said that these coalition districts were not required. But then you had Petaway that says that they're not authorized. I think in summary, I think I would say that that's the ruling there. There's a difference between those two. Wouldn't you agree?
I would characterize the holding of those cases differently. Bartlett versus Strickland said if you are going to say a district is required, that a district is mandatory under Section 2 of the Voting Rights Act, you have to hit 50% plus one. That's in lawsuits where you are suing to have a district created as a Section 2 voting rights district. What Petaway said was that you cannot combine different groups together to reach that 50%.
Correct.
What neither of those cases have said, and I think this is our primary disagreement with the DOJ letter's assumptions or implications, is that sometimes a majority-minority district is just there. And it doesn't need to be justified by Section 2 of the Voting Rights Act. It is simply there. It's there because of history, or it's there because it contains communities of interest. And just because it's there and it is majority-minority, neither Bartlett versus Strickland nor Petaway would say that that district is in any way unconstitutional.
Okay. But in the Petaway case, they went in through their analysis, the way I read it, 5 different ways that they said no, and overturned their previous decision in whatever that case was. You would know, but I don't.
Yes.
But so let me ask you a couple other quick questions. And I don't want to belabor this because we've got a lot of folks that want to testify, and I respect that. We've talked about coalition districts. We also heard some testimony today about opportunity districts. I've read some cases about crossover districts. Are opportunity districts and crossover districts the same thing, or are they second cousins, or how would you define those?
I know what a coalition and crossover district is under the cases as we have them today. I think the term opportunity district perhaps is a more colloquial term, and I don't have a legal definition for you. I think you would have to ask the person who is using that term, opportunity district, what the intersection of definitions is.
Well, and I agree, and I didn't see it defined under case law. I did see crossover districts defined, but not those. So, apologize. Let me go back to the other I think your testimony was that you can't tell me, as you sit here today, which is fine, whether the other three named in the DOJ letter are coalition districts or if they're not, and you can't really tell me if there might be other coalition districts in the state or not. But would you agree with me that in the event that it would be proper to fix or to address or to, as they say, remedy a situation with districts that may be coalition districts, one or more in the state, that you can't do that in a vacuum? In other words, it's hard to fix one district without it affecting other adjacent contiguous districts and maybe even districts across the state that you have to make work to get what would be proper under the Padway decision.
I need to respond to the idea that if it's a coalition district, it needs to be fixed, because there is no case that says that. The cases that we've been discussing, Bartlett, Petaway, are about whether plaintiffs can come to court and demand that a certain type of district be created, that there's an affirmative obligation to create that district. And that's where Petaway rules that you cannot combine minorities for that purpose. If you simply come across a district that is a coalition district, that doesn't mean it needs to be fixed. In other words, just because a district isn't required by Section 2 does not mean it's prohibited by the Voting Rights Act or the Constitution. There is space between those ideas, not required and prohibited. And the letter and the assumption here is that if it's not required to be there by the law, then it has to be dismantled.
But Petaway said that Section 2 of the Voting Rights Act does not necessarily create or mandate coalition districts, correct?
Petaway said you cannot sue to create a majority-minority district of combined minorities. That's very different than whether a coalition district that you come across that simply exists in the map is in any way problematic. It is no more problematic than a white district or a VRA majority district.
Right. And okay, I'll leave it at that. I do appreciate your testimony. Thank you.
Thank you for the opportunity.
Sure.
I like to discuss nothing more than redistricting,
Well,
so I appreciate your question.
You have come to the right place.
You're going to make me look worse and worse the farther we go in that discussion, but thank you.
Mr. Tepper, for what purpose?
Chairman, real quickly, I'm not sure.
There it is, Mr. Tepper.
Majority, minority might mean something different to me than it does to you. Texas is a majority minority state, meaning the other races outnumber white race. Does it mean the same thing to you in redistricting that it does for me politically?
No, probably not. In redistricting, we have very strict standards that are set by the U.S. Supreme Court and the Fifth Circuit. In the Bartlett versus Strickland case, when it was talking about majority minority, it meant a majority of the population. And sometimes, for example, in this circuit, it means a majority of the citizen voting age population. In Texas demographics, the Hispanic total population has just slightly exceeded the white non-Hispanic total population, but in terms of their numbers like VAP voting age and citizen voting age, those numbers are not the same.
Okay, thank you.
Any other member have questions for this panel? Representative Perez, patiently waiting. You're recognized to question the panel.
I just had a brief question from some of the earlier discussion regarding county administrative burdens. I believe there's a requirement that when these congressional lines are redrawn, it requires that counties then have to go back and renumber all of their districts. And I don't think that's something that's been talked about yet, during the course of this hearing. But if you could go over that, because that's going to be a significant cost for county governments to implement whatever these lines are drawn, to go back and have to renumber all the precincts within their county.
Because any new redistricting, depending on the number of districts that it affects, could have significant ripple effects. We have 254 counties in Texas. It could be that a very high number of counties have to do what is called precinct realignment. Your voting precinct is the little area on the map that you vote in, and everybody in a precinct has to vote the same ballot. So if a redistricting line cuts a precinct in half, the precinct boundaries have to be redefined by the county staff. It's an intensive process, and one that costs money and time.
As former county commissioner, we had to submit it by a certain time, but I guess they got to reconfigure the lines to make sure that all the elections are in line. So, but just thank you for pointing that out. It's another just administrative thing that I want to be sure that the committee was aware. Thank you.
Any other questions for this panel? We thank you for your testimony. This panel is excused.
Thank you.